and then give you a little backstory about the Thorpe case. We filed the first complaint in this class action case in December 2010, Christmas Eve actually. Alongside, ULS has been co-counseling this case alongside AARP Foundation Litigation and Aaron Fox, a law firm, who we could not have pursued this case without. We brought this case on behalf of 500 to 2,900 DC residents in nursing facilities. Under Title II of the ADA, the integration mandate that Sue has bravely made for us, into what it is today through the Olmstead case. Also, I want to say, make no mistake about it, it's Lois and Elaine and hundreds of people like them and Melissa who are responsible for the ADA. They fought. It's through their grassroots efforts and voices, you know, before Congress, in hearings in every municipality in this country, that the ADA is what it is today and is a living document that's evolving today. And I would commend to any of you some of the great documentary films that were done about it, about the origins, about ADAPT's contribution to this effort, about Bob Kafka, and many hundreds of people with disabilities who have been in the front lines of this fight for civil rights. So in our Thorpe case, we're seeking injunctive and declaratory relief, meaning an order that requires the DC government to develop and implement a system of transition assistance to help all the nursing home residents who seek to move back to the community to in fact realize that that step and move out of the nursing facilities. As we know from many different surveys and studies from AARP and others, between 80 and 90% of all nursing facility residents, young, old, middle-aged, do not want to live in nursing facilities. They are institutions. We know that for a variety of reasons, most prominently because they segregate people from mainstream society. Not to mention the fact that the Health and Human Services Agency designates them as institutions. Yet we still have people in DC government who question that and say, no, really, they're not. People are, in fact, there voluntarily, folks argue. And there we go. You have to realize that people like Melissa, as Joe referenced earlier, get their benefits taken away by the nursing facility. People who live on a fixed income of $700 a month on SSI in the community, once they get into a nursing home, that is cut to $70 a month, 70. So if you think that people who end up in nursing facilities have the wherewithal to get themselves out, to get housing, to get even on the bus half the time, you're under a severe misconception. Just as a little bit of backstory, the evolution of Thorpe, it's not like we woke up one day, having met Melissa and many others, and said, let's sue the District of Columbia. No, that's not how we work. What we did was we visited hundreds of people in nursing facilities soon after the Olmstead decision came down, starting in the year 2000. We met people of all ages who were just cut off entirely from mainstream society because they had a chronic illness, they had a stroke, they were hit by a bus or shot and sustained wounds, and didn't have their independent living plan in their back pocket at the time, didn't have their birth certificates, their identification documents, their checkbooks, etc. They lost their homes, pretty much, because nobody informed them, you have options. Instead, the message was they got into a hospital or NRH or any other place, and they asked them, do you have an accessible place to live? No. Well, then you're going to a nursing home. Last stop, the nursing homes. So what we did was we fought together with lots of disability rights advocates, including ADAPT, to expand the range of home health services in the community that up until then were only available to certain numbers of seniors, people 65 and older, in very limited number of slots. Most of the people are in nursing homes under a standard, the eligibility standard, because they need help with their activities of daily living, bathing, dressing, toileting, transferring, eating. So they need unskilled help from home health aides at much, much, much less cost than nursing facility services. And the fact of the matter is, once we got that range of home health services expanded to include all adults with disabilities, we then talked to people and heard that housing was a big problem. Wheelchair accessible housing was really the exception rather than the rule for people with low income. So we asked the Housing Authority whether they were in compliance with Section 504 of the Rehab Act, and lo and behold, we learned there were no wheelchair accessible public housing units, even though the DC Housing Authority had basically rebuilt its entire system under litigation about poor conditions and boiler problems, etc. So we started this journey by suing the Housing Authority in a class action lawsuit that resulted in 565 fully wheelchair accessible public housing units in DC. HUD added to that a little icing on the cake, bringing it up to close to 600 fully wheelchair accessible units. So there is accessible housing now for low-income folks in DC. Although it was very, very tough to break through what continues to be the misconceptions by everyone that there is no such housing. We continued going back to the nursing homes to urge people to apply for that housing. We actually brought copies, papered the nursing homes with DC Housing Authority applications, because none of the nursing home staffs believed that there was housing or wanted to spend any time offering this assistance to people who needed it. ULS modeled good transition practices for everybody over a period of approximately 10 years before we brought this lawsuit in 2010. So back to the present, we're up to the third amended complaint in this lawsuit. Our proposed class, still not certified, which Nick is going to talk some more about, consists of all people with physical disabilities who now, or during the pendency of this case, are in getting Medicaid-funded long-term care services in nursing facilities for at least 90 consecutive days, that is 3 months, who are eligible to live in the community and would prefer to live in the community if, instead of a nursing home, if the District of Columbia would provide the transition assistance they need so that they can access long-term care services. There's one standard, folks, for people to get nursing home services. It's under which you need to show that you need help with at least 2 of the activities of daily living that I listed before. Same standard to get services in the community. Therefore, everyone in nursing homes is eligible to live in the community. And in fact, the services in the community are more effective, one would argue, and in fact we've seen, because they're one-on-one. A person living in his or her home gets an aide working with just him or her. So the highlights of the Thorpe case thus far, the federal judge in our case gave us a wonderful Valentine's Day gift in 2012 and rejected flat out the district's attempt to move for summary judgment. That decision is available on Westlaw, as is our complaint and various and sundry other things that you can find on our website, which is in the process of being revamped. but you can look for it at uls-dc.org, or see Victoria Thomas, who's sitting in front, and give her your email address and she'll email it to you. The gist of the judge's decision in that wonderful Valentine's Day opinion was that the the mere existence of community-based services, which the district maintained was enough to comply with Olmstead, is clearly not sufficient. The district's transition of only 3 people as of fall of 2011 from nursing facilities compared to the goal of transitioning 900 under the Money Follows the Person program showed a lack of compliance, or sufficient allegations of a lack of compliance with Olmstead. That the failure to seek additional community-based service slots was also another indication of failure to comply. And one of the ongoing issues, they're all ongoing, I should say, but the district actually has the highest rate of occupancy in nursing facilities in the entire country, and this has been the case since 2000. It's still between 95 and 98% rate of occupancy in nursing facilities. And the failure to take any steps to even identify the 526 to 580 people who already expressed a preference to move out of the nursing facilities or take any steps to help them move out was another indication that in that judge's decision. We've done 2 rounds of discovery. We've amended the complaint, as I said, and added new named plaintiffs. Some of our named plaintiffs have passed away. A couple have moved out, and we've prevailed in a decision to keep them in the case, that their claims are not moot because they're subject to readmission to the nursing homes, and so their claims are considered inherently transitory, those of you who are lawyers or law students.
1 more minute, please.
Okay, so the district issued its first written Olmstead plan in 2012, which lacks all of the hallmarks of an Olmstead plan and fails to demonstrate any commitment to transitioning people. It's not a working system of transition assistance, and so we're fighting on. We're hoping we'll get a class certification decision soon and work toward a trial date. We're always open to settlement negotiations. Thus far, those have not been fruitful. So there we are.
Thank you.